Good morning. This is a presentation of the North San Diego County Realtors. I'm Jackie Oliver, and this program is Guide to Inspections. I hope that everyone is signed in. Okay, so let's go ahead and get started with the program. And just going to change slides here. Okay, there we go. This is the outline of what we'll be discussing today. There'll be a general background, then we'll talk about the agent and seller and buyer duties. And then we'll talk about those provisions in the residential purchase agreement that pertain specifically to home inspections. We're also going to discuss the statewide buyer and seller advisory, why that's important. And then we're going to take a look at a home inspection report. And the bonus is the flipper law, and I'm going to tell you how to handle that. Okay. Inspections are governed by statutes, case law, and standards of practice. What that means is that by statutes is like the Business and Professions Code and the Civil Code, specifically the Civil Code 1102.6 and other sections of the Civil Code. Then the case law is about different cases that support real estate transactions. And finally, the standards of practice. What are you supposed to be doing? How are you supposed to be advising your clients? So the CAR forms help to guide you through the process, but they're not enough to satisfy your agent fiduciary duties. The forms do not alleviate your responsibility to investigate, to understand how the process goes, because the buyers and sellers will say, they never told me what this means, and we don't know how to use this. They didn't explain it to me. So you have to explain it, but most importantly, you have to confirm that you explained it. I'll give you an example. So you have a discussion with your client about disclosures, and you go through all the disclosures. And because it's a discussion, there's no confirmation that you ever had the conversation. So then if you don't confirm it later on, if you're involved in a deposition or you're involved in a mediation or you're involved in litigation, they're not going to have anything to support that you actually had the conversation. So you have to turn the oral conversation into a written conversation. So you do that with an email or a text. Usually an email is better. You could do it by a letter, but it's going to be a lot slower. It's going to be snail mail if you do that. So if you do it by email, what you will say is that this confirms that we discussed the disclosures today. We discussed the transfer disclosure, the seller property questionnaire, and then whatever you discussed. And if you have any questions, let me know. So you want to be sure that they received that. You can actually say, please confirm receipt. Then you want to make a copy of it, put it in your file. So later on, when they say, I didn't ever receive an explanation, then you can pull that email out of your file and then you can use it as evidence. Now, if they say, I didn't discuss that, and they send you an email back immediately, no, you didn't tell me about the transfer disclosure, then you can respond to them and remind them, oh yes, it included your responsibilities and a lot of questions. So moving right along, we have a lot to cover. So I just wanted to make sure you understand that you can't just talk to people, you have to confirm that you're advising and counseling them using technology such as email or text. I think that text is going to be more difficult to print on. It's a lot easier to use email. Okay, next letter on C, depending on what the seller discloses to you, your buyer, the buyer will complete the buyer's election of inspections, the BEI. Example is the seller disclosure of slow drains should compel the buyer to order a videotape of the drain, because they don't ever order a videotape of the drain to put a camera down the drain to make sure that there's no roots clogging the drain, and that's why it's slow. So that's what you would want to do. You want to go through the inspection with them, or the transfer disclosure with them, and then you'll know what to inspect for. Now, inspecting the inspection itself, in other words, going through it, there's very few home inspections that ever come back clear. I mean, even a brand new home is going to have issues with it. It may have construction defects, or usually what we find is a resale home. So if you'll take a look at this picture, it says that 86% of the home inspections found something that needed to be fixed. So you'll see of that 86%, you'll see 19, almost 20% is the roof. And then you have it looks like 10% on the electrical, 10% on the windows, the branches overhanging the roof, gutters, etc. Sometimes you have air conditioning problems, driveway, sidewalk. Usually a good one is cracked concrete. Tell me when you haven't seen cracked concrete at a new home or resale. And then, of course, plumbing and water fencing, that type. So again, you're not going to always get a clear inspection, almost never. And again, not even on brand new construction, because there can be problems in a brand new construction. I, in fact, have had some cases with that, where there was construction and there was a problem with moisture seeping through the walls and then mold developing. So it's not very nice. So let's look at the legal requirements for inspections in California. There are government mandated points of sale inspections. Now, every one of you is from a different level of real estate experience. Some of you that have been in the business for many years are going to say, oh, this is the same kind of stuff that I know about. But there'll be new agents that haven't experienced this. And to be honest with you, I've been in a license for over 40 years and a real estate attorney for 26, and I've taught real estate at the law school. And I'm still learning new things because statutes change, forms get updated, new forms are formed, are created and put on zip forms. So there's a lot of stuff that comes up. Right now we have the fire hardening that is the hot topic. No pun intended. But anyway, let's look at the specific inspection criteria. These are the areas that are state specific. You have the structural elements, and they inspect the foundations, the roofing, the load-bearing walls for damage or deterioration. And another thing that comes up with that is that sometimes people do inspection or do additions to their homes. Well, so when they and add on to their home or make a significant change, there's sometimes permits involved. And so usually if you have permits, then you have the responsibility to follow the permits, and sometimes they come out, and most of the time they do come out and inspect. Now, as you know, there are a lot of people that say, oh yes, this was permitted, when it wasn't permitted at all. So your client should be going in and investigating the permits to see if they were really done. Or they may say it's not permitted, or my contractor said it's up to code. Well, what does that mean? So that means you need to rely on your inspection report and do additional inspections. So you'll see in the example that I give you, the home inspection report, there are often sections that they say, we recommend a roof inspection. We recommend additional plumbing inspection. We recommend that you have an electrical inspection. It depends on what they call out. Or you may want to inspect the crawl space because we see evidence of rodents, and then you may have them inspect. Not all inspectors go under the house, depending on what type of house it is. If it's on a slab, it's not going to have a crawl space. But if it's a raised foundation, it's going to have a crawl space. And if you have evidence of rodents or skunks or raccoons, you may have an issue. I've even had a client call and say, we found a raccoon in the attic. So, I mean, those things happen. There's also safety systems such as working smoke detectors. Number 3 is the carbon monoxide detectors. They're required in all properties, especially those with gas appliances. Why gas appliances? Well, they have open flames. That's a problem because you have carbon monoxide, and then you'll have a problem, especially with gas appliances. There are issues there. Water heater strapping. The water heaters must be strapped to prevent movement during earthquakes. And so you want to make sure the water heater is strapped, and your home inspection should point it out. Gas shutoff valves, mechanical and automatic shutoff valves must be installed to mitigate gas leak risks during seismic activities. So you want to have that. So again, those are the 5 areas of inspections and components for safety and compliance. Now, what happens if you don't comply? Well, if you don't comply, then it can lead to fines imposed by the state that don't meet the inspection standards. Like they say, oh, you didn't have a smoke detector in a certain area. So it might be a hall. It might be a bedroom was missing one, or it wasn't functional, because they'll go through and they'll test. The inspector will test to make sure they work. And also may have a delay in sale, and it may affect your transaction because you haven't taken care of those compliance issues. And then finally, the legal liability. Let me tell you, you're very busy, and you don't need to waste time on legal actions, because when you're involved in a lawsuit or even a mediation, you can lose a lot of time, and you'll be digging through information and files trying to find things that you haven't seen in a year or two. So the seller risks legal action from the buyers if the inspections reveal undisclosed issues, and that happens quite a bit. But some of the buyers don't read their transfer disclosure, and they don't do the additional inspections. So let's talk about what your duties are. Under the Civil Code, 2079, and all the little sections underneath it, there are fiduciary duties under the agency law that an agent must conduct a diligent visual inspection of the reasonably accessible areas. And you know the form, the AVID, Agent Visual Inspection Disclosure. That has a lot of questions, and it has information there and space for you to add what you see. So it has to be reasonable. You're not required to get under the house. You're not required to, crawl up on the roof. It's just what you see. And again, you have a transfer disclosure. We'll look at the RPA, and we'll see where in the RPA it shows where the transfer disclosure statement is supposed to be issued to the buyer within 7 days, unless you've changed the date. And then the buyers do their inspections, and they remove contingencies in 17 days or by what date you've agreed on by filling in the form. So you have agent fiduciary duties, and the seller has seller duties having to do with the listing information. You'll have a, I'm sure the North County Association has their own version of the SLIC, which SDAR has, the seller's listing information checklist, but you should have a checklist, and you want to make sure that the seller is providing what you need. It would be a good idea for your seller to fill in the transfer disclosure statement and the seller property questionnaire before you have a buyer, because then if you're waiting for a buyer and the seller thinks of something new and they say, oh, I forgot to disclose something, then they have time to fix the disclosure. And that's before you've provided, or it's been provided to you, or you've provided it to a buyer. So, and you'll find out that in June of this year, 2025, they have created a new form, and that new form is the advisory addendum to for prior inspections or prior disclosures like TDS, SPQ. So they provided a disclosure, but then they remembered something else. So now you can use the new form. But the issue with that is that it'll trigger a new time period for the to remove the contingency. So it can get pretty crazy with the deadlines. So again, the seller has the listing information checklist, and then you have the seller statewide buyer seller advisory, SBSA. And let me tell you, plaintiffs' attorneys and defense attorneys will use that SBSA all day long, especially the defense attorneys, because they're going to say, well, the SBSA says that you're supposed to make all these investigations. You're supposed to do all these inspections, and all of the inspections that the inspector has advised you, hey, you better check on an additional roof inspection, because they don't do the inspection, a roof inspection, like a roofer would do. So you have to look at that. The other thing is the allocation of inspection costs for like septic, well, property monuments, propane tanks. There's actually an SWPI for that specific issue, so that you're either sharing the costs, or the seller's picking them up, or the buyer's picking them up. Those are negotiable items. So you can put that in, but I've actually seen those break a deal apart, because the people haven't done their homework, because they don't know how much it costs to inspect each component. Or likewise, if the seller says, oh yes, we'll pay for all the costs, and then they find out one of the costs was a lot more than we expected. Why didn't you tell us? Well, you can advise them to go out and interview different contractors on what they charge for those inspections. But how do you confirm that you actually advise them? Because remember, you have a responsibility, fiduciary duty, to advise and counsel. So you need to counsel them on that issue and then confirm it in an email, so you have proof of the oral conversation. Now let's look at the seller's duties in depth. There's several. You'll see that the statutory disclosure, transfer disclosure under the Civil Code 1102, we call the TDS. And if you look in the Civil Code, which is a statute, you'll see a form just like the CAR form. The only difference is it doesn't have the little logo that says CAR and a little state picture of the state, because the transfer disclosure statement has to be exactly the way that the Civil Code is written. That's statutory. So when we get down to seller property disclosure, I will tell you how that's different, because it's not statutory, it's contractual. Number 2 is a receipt for reports. The buyer is going to have to confirm that they received the TDS, the SPQ, the SPQA, the SSR. So you're taking a look at the all the forms that they've received. Now, if they've received other reports, like reports having to do with construction of some part of the property, or having to do with a citation, that the city may have given them a citation the year before, and it's something that they need to disclose, that should be something that's check the box off the TDS where it says other reports, and then you use the receipt for reports to add that any other receipts, any other reports that you've received. So it could be for anything. It could be a seller getting a drain inspection after a backup, or I've actually seen where a septic tank is concrete caved in and had to be completely replaced. So they now have a new septic tank of a triple the amount of volume. And so if that's been done and they had permits on that, the seller needs to give all of that to the buyer. So receipt for reports, you've got them there, but remember, it's not all inclusive. You can put other reports. So I hope everybody's taking notes on this, because there's a lot more than on the slide that I'm telling you. You know, I'm speaking from personal experience. I do act as an expert witness on transactions. And so because of that, that's how I happen to know a lot about what can happen in a transaction, and know from firsthand experience. I've used to have 10 to 11, 12 listings at all times. When I worked in San Fernando Valley, I owned a Remax right there on Ventura Boulevard. And so I was selling real estate and representing buyers. And, you know, it's amazing that some of the properties that I was selling in the 1990s for $170,000 are going for $1 million. So that's another issue. So again, take notes. So any of the you have disclosures, and then you have supplemental forms. So if you look under 3A, you say the SPQ, it's already in the RPA. You would have to take it out of the RPA to get it off the contract. It's not statutory, it is contractual. So if they're using the residential purchase agreement as is, it's going to include the TDS and the SPQ. So there's also an SPQA. That's something that SDAR has, and you probably have an analogous form for your association. Then the seller statement on repairs, that's self-explanatory. Solar advisory and questionnaire, you don't need that if you don't have solar. Wooden balconies and stairs addendum. You know, earlier this year, they made effective the responsibility for wood balconies and stairs, anything extending over the main building. You have to have those inspected. I know a lot of you are already familiar with, there was apparently some college students having a party on a deck and it collapsed. So you can have wood decks that, you know, maybe have weak features. Either the wood is rotted or whatever. So you have to have an inspection, and you have to provide the WBSA, which is a wooden balcony and stairs addendum. It includes both the balcony and if there's any stairs. Then you have carbon monoxide detector notice. It has a health and safety code 13260 and also 17296, and then all the little parts that go with it, the 0.1, the 0.2, etc. So they have this carbon monoxide detector. I can remember a time when they didn't have this. I can also remember a time when we had a residential purchase agreement that was one page and a lot just lines, and you had to fill in everything. Then it went to 4 pages. Then it went to 16 pages. I mean, it's just been, I wouldn't be surprised if it's 25 pages in the next couple of years. I mean, it's just gotten crazy. There's also the bed bug disclosure under the Civil Code 1954.603. And if this is important when you have a listing that's a residential lease agreement. But even if you don't, and you had there were bed bugs in the house and they were treated for it, there should still be a disclosure. Then there's radon gas and mold notice. I don't see that a lot, but it's worth it to give the notice, because you can't over disclose. They say if a seller says, well, what should I disclose? I don't know. I don't know. Just, it's whatever seller, it's whatever you're aware of. That's the standard. It's a very low standard. It's what do you know about the property? And the what comes up when you have a buyer that sues the seller is they say, oh, they should have known that. You know, like the big hole in the roof was not a skylight. But then you can see in the new disclosures, it'll say, well, anything that the buyer could see on their own was apparent. Then if it's missed by the seller, they don't have to make a new addendum to the prior disclosures. But it would be a good idea to just do one anyway, just for safety blanket. And then you have the water heater and smoke alarm statement of compliance. And again, I just mentioned water heater strapping, etc. And then the water conserving plumbing fixtures. And we know what the low flow toilets, the low flow shower heads, those types of things. They have a disclosure for that. And of course, the CO detector advisory. So there's a lot there. Okay, let's look at the transfer disclosure statement in detail. Okay, when you start off at the top, you're going to define the property. Okay, is it a single family? Is it a duplex, etc.? And it's a disclosure as of a certain date. A home is like a living organism. It changes over time. I know many of you are homeowners, or at least you live in a home that might be renting, but you'll know from the time you move in to the time that you're either going to leave or sell the property or give up the lease, properties change. You might not have had a slow drain. You might not have had a leak in your roof. You might not have had a drainage problem, or a problem with the driveway, with the concrete, or problem with just about anything, bugs, you name it, rodents. You might not have had that. That's why in this first section on this slide, it says right in the middle there of that section, it says it's the civil code as of date. So that date should be as of the date of the disclosure. I've even seen some TDSs with no date in there. So you want to highlight that and make sure it's there. Now, the next section it says coordination with other disclosure forms. And they're saying that you have, you may have other forms that are with the transfer disclosure, like special study zone, and purchase money liens on the property that is not so much a home inspection, but you'll want to know, for example, if it's in a historic area. I had a case that I worked on that was in a area of Los Angeles, which was called Little Korea, and they had certain obligations about the architecture. So they might take a look at that if that's an area they want to live in and they have those particular ordinances for that area. And again, this is the area I was talking about on this bottom of the slide that you're looking at, the substituted disclosures. That's where you check off the inspection reports completed pursuant to the contract and the RPA, and then any additional inspection reports, like citations that were on the property and were removed. Even though they were cleared, you still want to put the citation and put the clearance on there. You don't want to leave an opening for a lawsuit or even a mediation. It wastes your time. It takes you away from prospecting and selling properties. Okay, section 2 of the TDS is the seller's information. And what I'm trying to point out here is that they say seller discloses with the knowledge that even though this is not a warranty, the buyer may rely on this information on terms of purchasing the subject property. Okay, and so the transaction requires to have a TDS. Now there are some that don't require a TDS. There are some that are exempt. Certain trusts, probate, they have exemptions. Okay, properties bought in foreclosure, they have exemptions because there's no way that the seller would know everything about the property. So this section at the bottom of that little block for seller's information, it says the seller is or is not occupying the property. So I recently had someone that contacted me and says, well, the seller doesn't live there. And this is an agent I've known for 20 years. And he said, was the filthiest project I've ever seen. It was in City Heights, 3 units. And they said, but the seller doesn't live there. They're all rental units. And I'm thinking, that's probably habitability issue, but you need a landlord tenant attorney about for that. But it's not, it's something that is the tenant's responsibility. But this box is very important because this is the box that if you're not occupying, seller's not occupying, well, then the seller's defense is that I didn't know about these things. I had a tenant in there. I didn't know that there was a problem with a drainage issue, and et cetera, et cetera. But the seller is occupying the property. That's when the buyer says they had to have known it because the damage that was there, our inspector says it had to have been there for a long time. This wasn't a new condition. So the seller has responsibilities, and likewise, the buyer has responsibilities. And there's a buyer transactional advisory, the buyer's investigation advisory, and in that, it's telling the buyer, you need to investigate certain areas. That goes through all of the areas they need to look at. And again, the transactional advisory is that, you're going to have these responsibilities. It's not all on the seller. It's you, buyer. You need to go do the investigations, and especially those that you've been advised to do by the professionals, the inspectors. So that's important. There's buyer material issues, and those are the things that the buyer says, oh, it's really important to me. It's really important that the fence is secured, or it's really important that there's no mold in the house because I'm very sensitive to that. So that's material to them. The seller's not responsible for anything they don't know about, so that you would have to advise the buyer, well, if you're sensitive to mold, you need to have a mold inspection. That's right. You have to hire someone that's an environmental specialist. I've done it myself just recently in the last 2 years. I am a trustee and I had to take care of some properties, and we had severe water damage. And sure enough, one of them had serious, serious mold, and the mold had to be remediated. And then after the remediation, then the hazard inspectors, the environmental inspectors came in and did a test, and then they provided a report that showed what kind of spores were found in there, what kind of bacteria. That was they did to begin with, and then afterwards, is there an acceptable level? And it turned out that there was an acceptable level after the inspection, the mold inspection. So that can be done if it's material to the buyer. If they want to make sure that certain things are done, then they need to inspect for it. So that's the buyer material issues. And we had another slide previously that mentioned the BIE. This is the buyer investigation elections. What are they going to inspect? Are they just going to have a home inspection, or are they also going to inspect the roof separately? Is this a place that property that's older and obviously has a couple of layers of roof? I recently had a transaction that I helped with and reviewed, and they had 4 layers of roof, and it was wood shake. And if you don't know what wood shake is, you should learn it, look it up. It had 4 layers. The inspector said this roof is really in bad shape. And this was $1.4 million property. But the buyers still wanted it. They wanted to buy the property, and I advised them, look, if you want to buy this property, you should get estimates on how much it's going to cost for the roof, because it's going to be more than just, you can't just put on another layer. You have to have a roofer give you an estimate. In fact, I would suggest 3 estimates, but as an agent, you should at least ask them to get a roof inspection in that case. It's not up to you to go out and get the estimates. You don't get the estimates, but again, if you give them that advice, confirm it and keep that confirmation in your file. You may not ever need it, but if you need it, you'll have it, and may save you a lot of time and may get you out of the case. So again, the buyer investigation elections, and there's this SPQA. Now, I know that North County doesn't necessarily have this form, but if you do have that form, it's the buyer's duty to exercise reasonable care, which it's already in the contract. It says, buyer, you need to use reasonable care when you're investigating. It's also in the SBSA that we just talked about. So that's important. Then there's the buyer contingency removal, and you know what that is. If they remove contingencies, they can remove a multitude of contingencies. You might have a loan contingency, you could have the inspection contingency, or there could be a condition that needs to be removed. For example, if in your RPA, the parties have agreed that the tenant that's occupying the property needs to be out by a certain date, and they're not out by that date. So that's a condition that you would not remove if they're not out by the date. So that's another example of a buyer contingency removal that you should be taking care of. Now, I know many of you have probably done those piecemeal removals of contingencies. It's not uncommon, but many times I've seen that all contingencies were removed all at once. And then when something goes wrong, that's something that I, as counsel, will ask them, well, why did you remove them all together? And then the agent's usually saying, well, no, we had already had all the investigations. And well, did you have an investigation that's specifically about the dispute? Because remember, this is a dispute, that the reason that they're complaining is they have a dispute over something. Now, if it's a misrepresentation on a required document such as the TDS by statute, SBQ by the contract, and there's it appears that there may be intentional or misrepresentation, that type of misrepresentation can result in rescission. What does that mean? It means that the seller has to buy back the house. So that's pretty serious. But remember, the buyer has to make their case. Which, speaking of cases, a lot of you know this already, but I'm just going to give you an example. There's statutes of limitations. That means that once you discover a problem, you only have a certain amount of time to bring an action. Now, under the RPA, it requires that you mediate first. So if they have a problem, they need to mediate. If it doesn't resolve at mediation, then they have to file a lawsuit. The buyer does, and then the seller defends. Okay, so in a breach of contract, which you could bring the SBQ under the breach of contract because it is contractual, then you could say, we have breach of contract, you have 4 years. Breach of contract has a statute of limitations of 4 years. Intentional conduct, fraud, has a statute of limitations of 3 years. And then negligence, it says, oh, well, they should have known, but they missed the disclosure, or they just, forgot about it, or was something that they couldn't, didn't understand or something. It was just negligent. Then that's a 2-year statute. So negligence as a 2-year statute, keep in mind that sometimes the agents and brokers are brought into the case. So if you're brought into the case under negligence, they have only 2 years to bring that action. So I think that's good for you to keep in mind. Now, there is I told you already, the confirmation letters, emails, texts, those are the ones that convert oral communication into a written communication, and it's the backup for you. You have your oral testimony, now you have a written testimony that's to the client, and that goes for both sides. Buyer, seller, landlord, tenant, okay? If you're doing those kinds of transactions, then you need to confirm it. Otherwise, it's hearsay. He said, she said, and it's not going to be good for you. So we move on. This is not, oh, there we go. Let me get back to the slide that I want. Okay, I want the next slide. Okay. The Buyer Investigation Advisory is a form, BIA. And this BIA in paragraph 1 tells you how important it is. It says you have an affirmative duty to exercise reasonable care. And remember what I said about that other form that's independent? There it is in the BIA. It says you have to exercise reasonable care. So what does that mean? It means that you need to disclose facts, and you make investigations, and the facts that you know or are known to through your diligent attention. They're also speaking to brokers. What's that form? AVID, Agents Visual Inspection Disclosure. Okay. If the I've already mentioned this, if the professionals recommend further investigations, any additionals, you need to do that. Let's look at the paragraphs in the RPA. These are paragraphs in the residential purchase agreement that speak directly to inspections. And paragraph 10 is the allocation of inspection costs. We've already talked about that, how your clients should be advised. Hey, you need to get an estimate on how much this cost is going to be before you agree to it. Or you agree to pay it yourself, or seller, you agree to pay for the inspections, and then they find out that they're not what they expected. I recently did an easement, and they had a legal plat map, but it didn't have a legal description, and those are two different things. And so they went back to the surveyor, and the surveyor said, oh no, we need another $1,800 to do the legal description. Now, they had done the plat map and had everything plotted out, but they didn't have the words that you see on your deed. If you look at the preliminary title reports, you'll see on the deeds that are included that, most of them are hyperlinked. You can click on deed and you'll see an exhibit that says legal description. It's not a plat map. So again, 3A, allocation of inspection costs, that's under 3A of the RPA. Then you have 3B, 11 are the disclosures, and that's the seller's responsibility and yours. And we talked about that. TDS, statutory. SBQ, contractual. Okay, and any reports that you have. We've already gone through that. And paragraph 12 has to do with investigations. Who's responsible there? The buyer. So B is the seller, paragraph 11, and the buyers are paragraph 12 under C. Now, let's look at the final verification. So say that you had a request for repairs, and the request for repairs it has, usually have a little laundry list of things that you want done, some plumbing fixtures, or they need to fix some paint that is not sealed, or etc. And so they make a list, and the seller receives it and agrees to it. And then they get there and they do a final verification. The VP final verification is not a contingency. So they have to give another form. So what do they give them? They give them the notice to seller to perform. Hey, seller, you were supposed to do this by a certain time and you didn't do it. So you can follow through on that. And then again, we have the allocation of costs and that we just talked about. And you'll look under paragraph 10 and you'll see, it directs you to 3Q 1, 2, 3, 5. And it says agreements for payment of required work, and a separate agreement. You see the RR, the RRR, the response to the request for repairs, etc. And then again, installations, it covers that. The parties are aware of it. It's in the RPA. And then again, what I've talked about under the statutory and contractual, remember that lead-based paint, and you've got that separate disclosure. And cancellation rights under the RPA, you can cancel a contract for non-performance. So this 11A talks about TDS, NHD, and other statutory supplemental disclosures. So that being mentioned, the NHD I haven't mentioned yet. And why is that important now? Because of fire hardening, they are putting in the NHD, the natural hazards disclosure, they're putting the fire zone. So if you're in a very high fire zone or a high fire zone, you're going to be subject to inspections. And for those properties built before 2010, that's a whole other class that I give. But NHD, that's something important that you should know, natural hazards disclosure. I know that a lot of people receive it and they never look at it. So they're paying for it and they're not using it. And you can see right in this A1, sort of in the middle, it's exactly what I just said. And under 1102 of the Civil Code, 0.6F and 1102.19, that it mentions that high or very high severity. So again, A3 talks about the supplemental disclosures at the SPQ, and I mentioned to you there are exemptions. Okay. The investigation of property is specified in 3L3. It's contingent upon the buyer's investigation of the condition, any matter affecting the property. So it says to see paragraph 12. So this paragraph is 8C of the RPA. So the RPA is contingent. Their purchase is contingent. So that if they haven't, if they want to remove it, they better be sure. Okay, so here's it 12. And again, it's the buyer's investigation of property. And then it lists, what's interesting is that A talks about within the certain time period at the buyer's expense. Remember, we just looked at a paragraph 10 and it said allocation of inspection costs. So now you see at buyer's expense unless the seller agrees to pay it. So that would be a negotiable item. Inspections, investigations, tests, surveys. I don't know if is the fence actually on the boundary or is it a few inches off? And then the people buy a property and then they realize, hey, this fence really isn't on the property line. But here's the contract, and it tells you that you better do your inspections and surveys. Now, how often in your transactions do the parties do an inspection of survey? Hardly ever. Now we're seeing a lot more of them. And why is that? It's because people are interested in ADUs. That's a whole other class. Why is it so important? Because there are certain setback requirements. A lot of people don't know that. They think they can just build to the property line. They cannot just build to the property line. They have to have the setback. Well, what if they don't actually have the property going up to where they think it goes? Because there's a fence there. So they think, oh, I can go up to the fence, or I can go 4 feet from the fence. But that's not the real property line. So now you've got a problem. So again, surveys are important. And then also B, it's talking about what inspections are you going to do? So you've got 1A, the general home inspection we'll take a look at. I don't want to run out of time. And then the pest control. It used to be at one time that the pest control termite was automatically in the contract. So it would say the seller will pay for termite. That's usually the way it was. And then they would pay for a clearance on the termite. So they would do the work if there was any work. And then sometimes, very often, and actually not often, I should say not often, because there's usually a little bit of work to do. So they'll do work and they'll get that certificate of compliance that it's clear. But sometimes I've seen it where there's no termites, there's no wood damage. And it's not just termites, it's also wood damage like, worn out wood, water damaged wood, etc. So this does not include the water test of the shower pans, upper level units, etc., etc. But this is telling you, hey, buyer, you need to inspect this. Now remember, go back to paragraph 10 where it said allocation costs. That's where you can say the seller, we're to ask that the seller pay for the termite. You don't have to, it's a negotiable item. The seller could say, no, I don't want to do that. Now that to me would suggest that why do they not want to do that? It doesn't cost that much. Is there a problem with it? Do they know something that they haven't disclosed? And in that case, if I'm a buyer, I definitely want to do the termite. So if that's an issue that is not paid for by the seller, I would pay for it, or the buyer to pay for it. Or they may not even want to buy the house, depending on the age of the house. I mean, you can tell by looking at the house, if it's falling apart, you might not want to buy it. But if it's a fixer, then that's a whole other issue. I have a bonus issue at the end that has to do with people flipping houses. So again, this paragraph 12 talks about the importance of the buyer investigation and then all of the types of reports. And the investigation advisory is also mentioned. And then I also mentioned that the 3J of the RPA says that it's not a contingency. It's only to confirm, did the seller make all the repairs that they agreed to? They comply with everything under the agreement that they entered into? And so that, again, I was telling you that if you have a problem, that you should bring it up there. If they haven't complied, notice to perform. Now, the RPA 7B refers to condition. What condition? It's the condition at the time of acceptance. Now, I mentioned something under TDS that had a blank for date. And what was that? That was the date of the inspection was completed. So the inspection, the TDS, that disclosure is probably maybe a month or 2 months before close of escrow, or at least 2 weeks before, or maybe even more. Because if the seller fills it in before they listed the property and they provide it, then you may have more time. So that's the seller's the date on the TDS. But here 7B says, what is the condition at the time the offer was accepted? Okay, these are some issues I want to point out on the SBSA. I've highlighted them. Do not look, the inspector does not look behind walls, under carpets, take equipment apart. I've already mentioned that. They don't go under the house or anything unless, well, sometimes they do. Um, they may have to have an inspection and, for example, a chimney sweep. And I've heard, I don't know if this is true, but I've heard that there's a lot of chimney sweepers, I guess you'd call them. They don't do it anymore, or they don't do it on certain houses, because certain houses, depending on the configuration of the chimney, they might not want to do that. Some of the older homes have some really funky types of chimneys, kind of curvy. And so the broker down in the next highlighted section, they may recommend that you have an appropriate professional for an area that the home inspector saying you need to do this. You need to inspect further into the drainage or into the plumbing or into the electrical. So sometimes the buyers elect to waive a certain physical inspection, or they rely on somebody else other than a appropriate professional. For example, my brother-in-law knows everything about construction. I'm going to take his word for it. Well, what do you say? Well, you're doing that is against what I'm recommending to you, and it's in the form. So let's talk about the home inspection reports. And what do they inspect? There's certain areas they inspect. I told you that some of the areas that they don't inspect, but these are the areas that they're looking at: structural, plumbing, electrical, roof, heating, ventilation, air conditioning. I mean, what kind of heat do they have? What kind of air conditioning do they have? And then they're looking at the hardscape. On the property that I was just handling as a trustee, we had an issue with the air conditioning. Now, this property was in an area that is very hot, and they had an evaporative cooler. And the evaporative cooler doesn't do well when there's a lot of moisture. It does well in dry climate, which seems like, oh, that's really nice. But buyers comparing central air with evaporative cooling, if you're competing with other listings in the area, they're not going to look at your listing if you have evaporative cooling. So the trust had to pay to put in central air. And what happened in one of they had a big family room in the back, that there was no ducting to go to that. The rest of the house had it, but when they put in that addition, they never had the ducting put in. So there was another unit that they put in that had air, and it was a little bit cheaper, so it wasn't bad. But again, they inspect the hardscape. Okay, I've gone through some of this. Additional inspections are based on the seller's disclosure. Again, if you have a TDS or SPQ and it points out certain things like, oh, you better check out with what the boundary is, because there's a dispute that we have with a neighbor who thinks that part of this belongs to him, and we think that the property line is elsewhere. Remember, they only have to tell what they're aware of. If your buyer wants to inspect, they need to inspect, especially if it's a material issue. And again, for the home inspector's observations and recommendations, and then your AVID. Now, what do you do if there's a previous transaction, the buyer received the home inspection report, which, by the way, if you look in the RPA, it says that the seller has the right to the buyer's inspection report. Unless they counter that out, they have to give them the report. So what do you do if you have another home inspection report? You can provide it, but the buyer should not rely on a company that they didn't vet. So they don't know the quality of that report. They don't know when the report was done. Yeah, it has a date on it, but they don't know the experience of the contractor or what they need, what they want to have inspected. So they should get a copy of the previous reports, but they should do their own inspection. And you need to advise them to do their own inspections. And it's in the BIA, the BTA, and the SBQA, which is the reasonable care. So they have to act with reasonable care. And it would be reasonable for a buyer to get their own inspection, even though they have the other inspection, and you're advising them to do so. Okay, so before we get to the flipper law, I'm going to try to switch slides. So bear with me. I want to show you a home inspection report. So I'm going to stop sharing for a minute and bring up the other reports. So bear with me. Okay, can you see the house and home inspection? I hope you can. If you can, put it in the chat and I'll take a look at the chat if you can see the home inspection report. Okay, it says that you can. Okay, let's look at this inspection report and you'll see it has a house. This happens to be one of the houses that was a part of the trust that I was trustee for. And I'm going to go down here. Now, you'll typically, if you have a good inspector, they're going to have a table of contents. And if this works, it should have a hyperlink to the different sections. So like I told you before, there are certain areas that they inspect. So they have a cover page I just showed you that is the cover page for the inspection and usually shows the inspection, but a lot of times it just shows a house and says, this is the inspection and it was ordered by, well, a lot of times it's ordered by the agent, but it says who it's ordered by. And then they have a table of contents and they have a general summary. So we're looking at the table of contents here and let me see if I can go down a little bit. Okay, and you can see all the areas that I pointed out before. Roofing, exterior, I don't know if I mentioned hardscape. Hardscape would be like those little retaining walls or, planters or decks that are made out of flagstone or they're made out of wood decking. Attics, crawl space, substructure. I mentioned the crawl space about the rodents being under it. The bathrooms, the kitchen, the interiors, electrical system, cooling, heating, it's all there. Plumbing, water heater, and we talked about the strapping of the water heater. Okay, and this is showing the roof. These are rolled roofs out there. And this is showing the side of the house, the exterior where the bricks, there was a crack going all the way down. And the reason I'm showing you this is because some of you have seen a lot of inspection reports, but often you haven't really looked at it. I notice that a lot of agents don't really inspect the inspection report. They're negligent in that area because when you have a problem, an action against you, you will have a plaintiff's attorney say, well, why didn't you advise on this particular part of the home inspection? Because they'll get it in discovery document production. They'll be asking you for all the documents that you have in your file. So the inspection should be in your file. But why didn't you point out this crack in the brick? Well, I didn't notice because all I saw were just two red arrows. I didn't really understand. And so here's another one, the exterior wall structure. And it actually has an explanation, whereas this house and home with the arrows doesn't have an explanation. It just shows you the wall. There's nothing underneath it. It just shows a picture. Now this siding has an explanation. The storeroom siding is heavily weathered. Advise scraping and painting the siding. Okay, that's not a big issue, at least to this inspector. However, if it becomes an issue, for example, if there's termites in that storage room, and you didn't have a termite inspection, and you didn't have anything on, you didn't even have a clearance, or they didn't inspect it. They had a termite inspection, and usually, a lot of you know this, they'll have a little square where the building is, and they'll have certain areas, and they'll point out and have highlighted areas that they found termites or wood damage of some sort. But sometimes, and many times, they do not inspect sheds and outbuildings, etc. So just because he says advise scraping and painting siding, that doesn't mean that you shouldn't check in with a wood specialist, a termite specialist, to find out. Here's okay, entry doors condition, heavily damaged at the rear patio, utility closet door, advise replacement of door by a qualified party, excess dirt. Why am I showing you this report? This report is terrible. That's exactly why I'm showing it to you, because you need to see what a bad report looks like and know what to ask. Okay. And here's one. I bet you didn't even need to have an inspector look at this. This is a utility door, and it had a vent on it at one time, and that's where the water heater is, and the heater is in that space. And you can see where it's other vents, and that is showing, you know, a damage. And you can see, I don't know if you can see it, but it looks like a gas meter, and that gas meter is all taped up with you know, black construction tape. Entry door, and you'll see many comments about fair, satisfactory, good, etc. You won't find many good in this report. Rear patio sliding glass door does not latch. Advise repair a door, again, the same thing, so that you can latch. Well, this particular house had doors that were wrought iron, and so they had their own lock. But within the wrought iron would be a sliding glass door, because even though you have the wrought iron, then if you didn't have a door, then anything could come in. Rain, bugs, you know, anything can come. People can't get in, but other items in the environment can come in. Column conditions. Here's a example of wood decay damage on at the carport, and you can see where the arrows are. They have a far away picture, and then they have the close picture to show that the possible presence of subterranean termites. So it tells you to do further evaluation by a pest control expert. And remember, the RPA no longer has that in it. People have forgotten that they need to get a termite inspection. And if they have problems, they need to clear it. And if it's too much, that would be a basis to cancel. And let's move on. Now, what do you think that is? Crack in the concrete. That's in the driveway. And so that's a problem. They say, now why why would they say fair condition? I don't know. So to some people, they don't care. Cracking noticed at concrete driveway, considers sealing to prevent worsening the condition. And here's another thing. I don't think it's in this particular report, but the hardscape should not be directed or slanted towards the house, because then you could have water damage at the base of the home. Okay. Um, there's more on the bathroom. I'll go through this quickly because we're getting close to, we want to get some questions in at the chat at the end. You can see, looking at the picture here, that they're saying that the cabinets and countertops have heavy damage. Of course, they say it's poor. You should replace the bathroom cabinet, countertops, have it inspected by a qualified party, not your brother-in-law. So, kitchen fare, multiple chips at the kitchen. See, there's the sink. You see the rust all around. I don't know if you can see my cursor, but there's rust all around and chips, and you can see the drainage there, and it looks like there's a drain there, but it's drain cover, but it's upside down, and then there's some sort of a drain cover on the other one, the other sink. Leaking noticed at the kitchen faucet. Now, isn't that nice? And I don't know that CLR would take care of it. That's for many of you that don't know, that's the calcium, lime, and rust. It's a spray. Don't go in, and if you're having a listing, don't try to be the fixer, okay? Because you could get yourself in trouble. Let it be listed as is, or advise your seller. You know, that I would recommend that you do something about the kitchen sink and the faucet. I mean, it's up to you, but I think it would be something that would help sell the house, easier to sell the house, because they're looking at the condition. Okay, so you're making a suggestion. You make that suggestion, what do? You confirm it in writing. And of course, they talk about the cabinets. This one's missing a door. This is kind of a funky situation where, even though the stove is new, they have this counter that is just the weirdest thing. Now there's some water stains on the ceiling here. But they didn't notice any moisture at this time. Remember, this is hot weather. This is an area that is dry and hot. But what happens when the monsoons come and it rains? Then are you going to have leaking? That's something that you need to have inspected. Here again, water staining in the utility closet. Interior doors, there's no closet doors, and some of them have closet doors, but it actually says to install closet doors, which was done. Mirrored closet doors were added to this. But what's interesting about these closets is it does have there are divisions there where you can put shoes and hang clothes, and store. You have your dresser drawers and stuff like that, which is kind of nice to have. This one has one of those doors that's like an accordion door, and those can be difficult. Handle lock does not function. You have a you have a door lock here. It's got two different types of handles on it, and it says cracked door hardware. That's got to be old. Okay, here's a picture of what I was talking about before. Here's the wrought iron, and here's the glass door. The glass door did not latch, but there is security there, and so there is a lock there, but it keeps everything out. But if you didn't have this sliding glass door, then you would be allowing, um, you know, water or bugs or whatever to come in. Here's showing the electrical, 3 prongs, 2 prongs, and this was fair. Poor on the ground fault circuit interrupters. You may or may not know that you're supposed to have these GFCIs in anywhere where there's water for outlets. Plumbing, it shows the galvanized plumbing, and that there's, even though it's galvanized on the outside, they noted copper plumbing inside. Corrosion at the rear patio utility closet. That was one we were looking at where the paint was all and the wood was coming off. Anti-siphon device present. It says no siphon device, so you can, it stops the backflow from happening. Okay, moving right along. Okay, I want you to take note of this. I remember I was talking about the remarks that they would make: satisfactory, fair, poor, not applicable, etc. So they talk about all the different issues. They got roofing, the styles, and you will see here's a roofing grid, and you'll see how many: satisfactory, fair, poor, not applicable. And again, this is the roof. I think this is the slide that first came up. It's a rolled roof and has some issues. They have a vent pipe coming up here, and of course that's not sealed. These are a rolled roof, and then they're painted every year. I will say that the property is in Arizona, so it's a high, it's a hot area, and so they want the roofs to be white, so they're not so hot. And again, here's a grid about the exterior. Okay, and so you can see all the different quality of the or condition: satisfactory, fair, poor. Okay, and we've already looked at that picture and this one. That's a crack in the slab that's holding the shed. So you've seen a report. I am going to, I'll take you to the end. There's a color picture. And again, all of them have a grid afterwards. It's kind of like a summary. Okay, and the reports vary. They vary greatly. They it depends on, number one, the inspector, number two, the location. And believe it or not, in San Diego County, you have different like microclimates. You have the coast, and even along the coast, you have different areas that are have different conditions. Then as you come inland, that it changes. But if you have like Carmel Valley and then or La Mesa, you're coming inland, but it's not the same thing as the far East County. So it gets drier and warmer out here. Just look at the weather reports, or go on an app online and look at the weather reports. So we've gone through a lot of this. Oh, that's the gas service. And you'll want to know that because, actually, to tell you the truth, there's people that have been living in a house for 60 years and they really don't know the parts, you know. For example, I just was visiting with a 91-year-old lady, and her husband had passed away a few years ago, and they had an interesting property, 3-story property that he built. He was a bricklayer, and she didn't really know a lot about the property. It had a lot of steps, and I'll tell you, for 91 years old, she was getting around. But this is an example. Oops, I don't want this on. This is an example of, let me get this out of here, trying to get rid of this news. Okay, there we go. It escaped and it let me out. So a lot of, there's people that really don't know their properties. And let me go back to this one picture. They mentioned the water heater, and they mentioned the galvanized plumbing. If you look on the side of the water heater, you're going to see this copper plumbing. And that's how they know, and also by their other observations, that's how they know is there's copper inside. Now, that being said, they don't go, they don't search under carpets, etc. So there's a lot of issues there. This report is 51 pages. I've seen others that are far more than that. I'm going to stop the, I'm going to stop sharing. I'm going to go back to the PowerPoint. So give me a chance to get that back up. Okay. You should be able to see the screen. And if you can see the screen, somebody put in the chat um, whether you can see it. I'm not hearing from everyone. Okay, I can hear. So you're back. We're back on this, the last slide here. One second to last slide. There is a flipper law, and the flipper law means that investor may buy the property so that they can fix it up and sell it. So if they do that within 18 months, they have to uh, disclose every contractor that worked on the property, how they, all their phone numbers, etc., what was done, if there were any permits um, drawn or pulled. I mean, there's a lot of issues that they have to do. Now, what am I advising you to do? I'm advising you to build a disclosure file as they are making the repairs. You can advise your client that intends to flip it. You can advise them of that they have to make these disclosures if it's within 18 months. Now, what I've been seeing in reality is investors selling the property at 20 months. So what they're doing is they're getting around the law. Now the law is the law. It's 18 months, but they should, most people that are investors like this, it's not a big deal. They can provide the contractor. And a lot of times it's a general contractor and they may have subcontractors, but there's significant consequences if they don't. But the law was put in place because there were a lot of people buying properties, fixing them up, and what we call it in the business, putting lipstick on a pig. It's still a pig. So some of these properties were really horrible, absolutely horrible. So we don't want to have that problem. We're going to go to the questions in the chat. And I thought I would share this slide with you because that may be where you are after I've been babbling for all this time. Let's go to the chat. And I think that's pretty much it. And you have one of the best associations. The North San Diego County Realtors it provides a lot of educational opportunities. So I hope that you will take advantage of that. I will go ahead and sign off. Thank you for joining me today.